So you're gearing up for the July 2026 NextGen Bar Exam? Well, let's get right to it. The game has completely changed. Rote memorization? That's out. What the examiners want to see now is if you can actually think and act like a real practicing attorney. In this explainer, we're going to break down exactly what that means for the torts section. Let's dive in.
Okay, here's our game plan. We'll start with how to approach this new exam the sovereign way. Then we'll hit some key torts doctrines you absolutely have to know, comparative negligence, strict liability, and that all-important animal rule distinction.
You know, success on the NextGen Bar, it really demands a whole new level of thinking. It's not about just spitting back rules anymore. It's about getting a complex, messy set of facts and using the law to engineer a precise, logical, legal solution. It's about how you think.
And let's be really clear about something. The skills you're building for this exam, they're the exact same skills that define a top-tier legal career. This isn't just about checking a box to pass a test. You are laying the analytical foundation that's going to pay dividends for decades to come.
So what is this big shift we keep talking about? Well, we're moving away from memorizing rules in a vacuum and into a world of integrated skills where what you know and what you can do are one and the same.
And I can't stress this enough, this is probably the most important thing to get into your head for your study plan. The old ways of doing things, they just aren't going to cut it anymore. The old bar exam treated torts like some kind of trivia night. It was just a minefield of tricky multiple-choice questions, you know? They were designed to test your recall of some obscure, random rule, not your ability to actually reason like a lawyer. But now, the focus is all on these integrated tasks. The NextGen exam is designed to feel like actual legal practice. You'll get a client file and you'll be asked to do real work, draft a memo, advise a client. And honestly, torts is the perfect subject for this new format. And here's the beauty of it. Every single torts problem, I don't care how complicated it looks, it follows this one elegant logic. It's the story of a broken duty. We always start with the duty, then we find the breach, we have to establish causation, and finally, we figure out the damages. This is your roadmap, every single time. All right, let's get into our first deep dive, comparative negligence. This is the modern standard all across the US, and believe me, you'll be expected to handle its nuances with, well, surgical precision. Okay, you have to master these two systems. It's non-negotiable. In a pure jurisdiction, it's simple math. A plaintiff can be 99% at fault and still get 1% of their damages. But in a modified jurisdiction, and this is the key, there's a cliff. If that plaintiff's fault hits a 50 or 51% bar, they get nothing, zero.
And this just shows it perfectly, right? That 51% bar rule. Watch as the plaintiff's fault just creeps over that critical line. The scales of justice tip hard, and their financial recovery just plummets straight to zero. It is truly an all-or-nothing game.
Now, here's where so many people trip up. You must show your work. Don't just state the rule, apply it. If the damages are 100 grand and the plaintiff is 30% at fault, your answer has to clearly state that they recover $70,000. That's the level of precision the examiners are looking for.
All right, let's pivot to strict liability. You know, bar examiners absolutely love this topic, and it's because it's so counterintuitive. We're talking about liability without anyone being at fault.
The core concept is actually pretty simple. If you engage in certain specific activities, you are on the hook for any harm that results. Period. It doesn't matter how careful you were. The defendant's reasonableness? Totally irrelevant. So for the NextGen exam, you need these three triggers locked in your brain. First, abnormally dangerous activities. Think transporting explosives. Second, wild animals, even if someone claims it's tame. And third, products liability, for when a product is defective.
And that brings us to a classic bar exam trap, the distinction between wild and domestic animals. Examiners love to test this because the rules for each are just night and day. For wild animals, we're talking lions, bears, pythons, strict liability is the default. End of story. But for domestic animals, like a dog, the common law usually applies what's called the one-bite rule. You've got to prove the owner knew, or at least had a reason to know, that their pet had a mean streak.
So let's just walk through this. Before the first incident, the owner has no idea, so there's no strict liability. But after that first bite, okay, now the owner is on notice. Any harm after that, they're liable. But, and this is a huge exam tip, so listen up, always check the facts for a statute.
Lots of places have laws that make dog owners strictly liable from the very first bite, and that statute will completely override this old common law rule.
Look, the NextGen Bar isn't just another test. It's a new standard for what it means to be a competent professional. By mastering this way of thinking, blending what you know with what you can do, you're not just preparing to pass, you're preparing to excel. So the only question left is, are you ready to start thinking like the practitioner you're about to become?
All right, let's dive right into one of the most critical, high-stakes areas you're going to face on the NextGen Bar Exam: Products Liability. This is where those super complex fact patterns can really make or break your score, and where truly sharp analysis is going to make you stand out from the crowd.
Okay, so first up, we've got the manufacturing defect. The absolute easiest way to think about this is as a one-off fluke. Just picture a perfect assembly line, right? It's churning out thousands of flawless products, but then just one of them comes out wrong. It's got a screw loose, a wire crossed, whatever. That's your manufacturing defect. It's a total anomaly that makes that one specific product dangerous.
Next, we've got the design defect. And this is a whole different beast. It's a much bigger, more systemic problem, you see. This is no longer a one-off fluke. Here, the entire product line is dangerous, even when every single item is made perfectly, exactly to spec. Why? Because the flaw, it's in the blueprint itself. And the key test you have got to know for the exam is the risk utility test.
And that test boils down to this single crucial question. If you remember nothing else, remember this. Was there a reasonable alternative design? I mean, could the company have made a safer version that was also affordable to produce? This question gets right to the heart of the risk utility test, and nailing it shows you get the delicate balance between keeping people safe and allowing for innovation.
And finally, the third one, the warning defect, or what we often call failure to warn. This happens when a product has these hidden dangers, risks that you couldn't just guess by looking at it, and the company doesn't give you a clear enough heads up with labels or instructions. The classic example? A medication with some rare but really serious side effect that's just not mentioned anywhere on the bottle. That is a textbook warning defect.
Okay, so we've got the rules down. But theory's one thing, right? Let's apply them. We're going to run through a realistic next-gen style simulation. This is exactly the kind of messy, multi-layered problem you'll be up against, where you have to blend the hard and fast doctrine with actual practical skills.
So here's the setup. A company called AlphaBuilt makes this fancy new robotic scaffold, and it collapses. We've got two victims. First, there's John, a worker who, and this is key, wasn't wearing his safety harness. Then there's Sarah, just a passerby, who was walking in a clearly marked no entry zone. Right away, your mind should be firing on all cylinders, spotting the main product's liability issue, but also layering in those big flashing red lights for the company's defenses. And this is exactly how a top-tier lawyer maps it all out. It's not just a random list of issues. For John the worker, his strongest claim is products liability. But the key defense against him, his own comparative negligence for not wearing the harness. For Sarah the passerby, her claim is a more straightforward negligence case, and the company's defense is that she assumed a risk by ignoring the warning. This is how you structure your thoughts for maximum impact and maximum points.
Okay, so you've done the analysis. You see the whole chessboard. But look, knowing the answer is only half the battle. Drafting a truly winning response, especially with the practical focus of the NextGen exam, is how you actually lock in that score.
For years, we've all had IRAC drilled into our heads: issue, rule, analysis, conclusion. And you know what? It's fine for just spotting problems. But the NextGen exam is testing something more. It wants to see if you can be a counselor, a real strategic advisor. And that's exactly why we are upgrading to the Sovereign method. It totally reframes the task, moving you from a simple academic exercise to a professional, client-focused recommendation.
This method is a game changer because it fundamentally shifts your perspective. You don't start with the issue, you start with the client's goal. What do they actually want to achieve? Then you lay out the legal rules, concisely. Third, you apply the facts. But you don't just finish with a conclusion. You provide a strategic recommendation, a clear, actionable roadmap for your client. It's the huge difference between saying, well, here's the law, and saying, here's what we need to do.
Now, let's zoom out. Let's go from tactics to the big picture strategy. Honestly, this is the most important part of all, adopting what we call the sovereign mindset.
Just let this sink in. The law is not just a set of rules. It is a tool for protection, risk management, and wealth creation. This is the core philosophy. Mastering torts isn't about memorizing a bunch of elements for a test.
It's about fundamentally understanding the principles of risk, which is the language of business and, frankly, the language of life.
This is your future role, perfectly captured. Your job as a lawyer in this new era is to be the bridge. You connect the abstract legal doctrines we learned in school to the tangible, messy reality of business. You don't just spot issues from a textbook. You solve real-world problems, and you create real-world value.
So let's bring it all home. What you have now is the complete framework to not just squeak by, but to truly master torts on the NextGen Bar Exam.
I mean, just think about what we've just covered. You've mastered the 3 defects of products liability. You've applied that knowledge in a tricky, integrated simulation. You've upgraded your entire response strategy with the Sovereign method. And most importantly, you started to adopt a mindset that's laser-focused on managing risk and creating value. That is huge.
If this strategic, professional-level way of thinking resonates with you, if it just clicks, then make sure you subscribe to the Sovereign Counsel. We're all about helping you continue down this path to total mastery.
And you'll definitely want to join us next time. We're giving you a sneak peek into a topic that I know is on every single future lawyer's mind: legal assets. We are going to break down exactly how you can manage law school debt while at the same time actively building a 7-figure portfolio. And we are talking real strategy here, not just theory.
So we've given you the blueprint. The entire framework is yours now. The only question left is, how are you going to build your sovereign practice? Stay sharp, stay professional, and remain sovereign.